Thank you very much. Thank you, Henning. That's very kind for the introduction. Thanks, everyone, for coming. I understand the beginning of semester. This is busy time for all of you. We're all living a very busy life. Our teaching timetable is different from yours. This is actually the end of our autumn semester. We are now breaking for Chinese New Year for around 1 month. And we'll be back for teaching at end of February, right? Chinese New Year will be the beginning of February, right? So, very nice to see the young people on the campus. A lot of bicycles, that's all similar. and it's nice with heating functioning in this hall, right? That's been fixed. I'm from the university. It's called Beijing Normal University. Oh, believe me, there's no Beijing Abnormal University. Normal University we use this as a French way as a normal school in Paris. It was established more than 100 years ago in 1902 by Chinese emperors in Qing Dynasty. So it means we're setting the norm, the high-level school, something like that. And now it's a comprehensive university. We have a small law school established around 13 years ago. So it's a small school and very new. What I'm going to talk about tonight... Okay. Yes, I want to share with you a new law in China. It's about e-commerce. And China is the world's largest e-commerce market, especially the online retail market. That's primarily because we have the world's largest population, 1.4 population in China. And now internet penetration rate is about 50%. So more than a half of Chinese are now online. So just imagine how big the market would be. And for this Chinese largest e-commerce platform, it's called Alibaba, I guess it's also running in UK. Just in one day, it's called the Bachelor's Day, or single day, last year. This one day sales volume exceeded $30 billion US. It's very considerable. And this exactly because of this e-commerce platforms enable Chinese scalable development in this field of online marketing. These e-commerce platforms, first of all, they're internet intermediaries. That's pretty clear. But also, they are running a kind of virtual marketplace, and it's actually a global marketplace. Well, I don't know how many of you have been shopping on Alibaba. Well, Alibaba Inc. Is a group company. It has many platforms. I understand there's some friends from China. Hey, yeah. Sorry, you have a question? Me, I myself. Oh, really? In China? Here in... Oh, wow. So, is this Alibaba.com?
I assume it's one of the suite of websites that probably have a group that exports it.
Wow. So that truthfully means that's a globalized market. If you were using Alibaba.com, that's actually a platform registered and established in Singapore. I wonder whether you read through the terms of services. Did you read through that? There's a very long document. All right, it said, yes, it is a Singapore law, and Singapore jurisdiction apply to this platform, right? So not Chinese law. But for the people from China, they're using another platform also from this Alibaba group. It's called Taobao. That's very big, or Tmall. Yes. I guess in the little flyer I presented to Henning, I mentioned the extraterritorial the possibility of Chinese law. Yes, it's quite possible. Just imagine, for the Chinese largest platform running by Alibaba, there's Taobao. There's more than 10 million merchants operating on the platform. So the people are doing business there. And all these 10 million merchants will have to be bounded by the term of services on the platform. Or just imagine if that platform is actually governed by Chinese law, and they will be applicable to all the merchants on that platform. So look at the law, the Chinese e-commerce law. It is so new. Today is 18th of January 2019. The law was not effective until the first day of 2019, right? So it's been ineffective for 18 days. It's so new, no case so far. We haven't got time to test this new law. The law went through a very long process to be completed, and the lawmaking process began from 2013. The Chinese National People's Congress launched the lawmaking process 6 years ago. So that means 5 years drafting. And 4, it means it's been revealed 4 times at the Congress. This is quite extraordinary. For most Chinese law, they are revealed 3 times at the Congress. So normally the third reveal will be the last reveal. It seems the e-commerce law is more controversial, so it was not approved at the third reveal and went through an additional one. It was finally approved at end of August 2018, so that means 4 reveals. How about 3? It went through 3 public consultations. So each time after the reveal, it will be published, released for people's criticism, and many proposals were submitted through the websites of the Congress. And the draft or the bill would have to be revised. How about 7? If you look at the law, it's not a very big one. It had 7 chapters and totally 89 provisions, 89 articles. Oh, for the lawmaking process, there's something interesting. The National People's Congress is Chinese highest legislature. Normally, the bills of laws were prepared by the ministries, governmental agencies delegated by the Congress. That's quite normal. Like copyright law was being drafted by Copyright Office. But this time, it's very interesting. Chinese National People's Congress took it over. It drafted itself. Why? That's because e-commerce is a really complicated issue. It's very hard to be delegated to one governmental agency, for example, the Ministry of Commerce or the General Administration of Industry or Commerce. Another reason is that these are so many governmental agencies, including the MOC or the AIC. They have the conflict of powers. They want to extend their administrative powers to e-commerce to avoid these administrative conflicts. So the Congress took it over and wanted to play a neutral role. But of course, to my rough calculation, there are 18 Chinese ministries or governmental agencies involved in this process, and they form a high-level leadership group with 18 ministers in the group. Of course, they're very busy. They don't have time to draft the law themselves. So the National People's Congress actually formed an expert panel. This panel, in which I'm one of the members, is actually the pen holder for drafting. Of course, we're not making decisions. It's up to the congressman to decide. Look at this new law. This is some keywords I could see. The first one is the law is quite different from any other Chinese law. It's a comprehensive law. Just look at how many legal issues is being addressed. Even though its name is e-commerce law, it is not limited itself to contracts at all. For most e-commerce law in the country, it means e-transactions. But here, there's only one chapter, few articles about contracting. There are many other issues that's being included here. So it's more like a common law systems statute rather than a civil law country's law. For example, e-payment, delivery services, data protection, cybersecurity, consumer protection, dispute resolution, market competition, cross-border e-commerce, and especially intellectual property law, including copyright. That's something I want to talk about. It's so comprehensive. So now you see it can be really covered by one single ministry because it's complicated. The second key word is a basic law. I assume the Chinese government is attempting to making this law as a basic law for the digital economy. So e-commerce is not only one industry. E-commerce has become the basic infrastructure, like the electricity for first industrial revolution. At that time, at the beginning, only few industry used electricity. Now that's totally unthinkable. In the future, e-commerce will be used by all the business, all the sectors. So yes, it will be laid down the basic legal framework. And the third one is creating some new legal systems, some new legal designs. Some of them are not really new in the world, but it's really new in China. The fourth word is that they try to be compatible with international law, especially international trade law. The Congress has been working very closely with UN and UNCITRAL, as a UN Commission for International Trade Law. If you want to have a quick look of the scope of application of the law, it's interesting. It's that the law stated very clearly it is only applied to e-commerce within the territory of China. Well, that's interesting. Does it mean that it has no impact to any foreign businesses? No, it's not the case. It all depends how to interpret e-commerce within the territory of China. For example, for trade for consumers, B2C, you are a business in UK, but you are selling something through a website to Chinese consumers. For the purpose of consumer protection, the Chinese consumers would be eligible to claim to apply Chinese law, including the consumer protection rules in this law. Another possibility is a platform. The many platforms actually registered, established in China, and for all the businesses using the platform services, they are also subject to the platforms law. Yeah. Okay. Go down to copyright. If you look at the law, there are around 5 articles on intellectual property. Here I use a copyright. It's not limited to copyright. It covers the patent, trademarks, the GI, and many other rights. But here I mentioned copyright issues only. For the people, I truthfully believe you haven't got time to read through the law. If you take a quick look, you will see this is nothing new. It's just something like notice and take down. But if you take a closer look, you feel this is something like notice and take down plus, with a content notification. Still, it's not very new. But I strongly suggest you to read between the lines, and you will find something interesting. Let's look at the legal designs. Tripartite of the legal designs regarding copyright. I mean, there's the 3 parts, 3 components in the whole system. The first part is that all the platforms, they shall compose the rules for copyright protection, and they shall cooperate with copyright owners. They shall enable effective copyright protection on the platform. This first part. The second part, that the platform will take certain measures, including take down the contents that's been notified by copyright owners, and these merchants whose content has been taken down will be able to send the content notification. So for the measures. The third part is the liability. Is about if the contents did something, they will be liable. They will be punished under the law. Let's take a look. It won't be interesting to describe these articles. Instead, I suggest to look at these the 3 parts in a holistic way. If we try to interpret the 3 things in a system, I suggest we use the term platform governance. Of course, there's no definition for that, but there is a working definition for internet governance. It says these platforms offering a virtual marketplace, they're providing many services on the internet. So probably we can borrow that terms. These platforms, in the first place, they are providing storage and delegation services for merchants on the platform. They can also provide some value-added services, for example, the e-payment service or the delivery service, warehousing services. They can even providing the financial services. For internet governance, this is a definition developed by civil society group at a WSIS process, as World Summit of Information Society. That's a UN process. They try to reach consensus on this critical internet things. This definition is actually worked out by my friends from Germany and Switzerland. Okay, when we look at this working definition, it seems it's still working. First of all, it means a group of stakeholders should work together. They means governments, private sectors, and civil society. They should work together, of course, in their respective roles. This is very controversial. What is respective roles? In some countries, it means the government should take a leading role. Anyway, they should work together and try to develop and applicate the principles, norm, rules, procedures that shape the development and use of internet. Yes, so these stakeholder groups, these people should work together to build some rules that enable internet development. That's roughly the meaning of this definition. For the platform governance, if we borrow this, it also means a group of people. The various stakeholders should work together to work out the rules I just mentioned. And of course, when they're doing so, they should comply with the principle of transparency and accountability. Let's see whether the Chinese law is doing that. Okay, look at these, one of the provisions in Chinese e-commerce law. It's not limited to these 5 provisions specifically on intellectual property. This is also about the general platform governance. The law requires the platform to formulate the rules, and here it is used copyright rules. This is one category of rules the platform must develop. They have other rules they must develop, like consumer protection or data protection. When they develop these rules, first of all, they need to cooperate with copyright owner. And secondly, they should comply with the principles of fairness, transparency, and impartiality. Well, this looks quite empty. This means how a set of rules could be prepared and developed. This is not very clear. It is really multi-stakeholder, not very clear. Then look at the second part. This is not really about the formulation or preparation of the rules. This is about modification. When we look at the requirement of modification of the rules, it seems it is more clear. It says the platform should solicit the comments, and they should they should invite all the parties involved. Interesting, they use the word all the parties involved to express their opinions timely and sufficiently with respect to the modification of the rules. Well, here it seems it's pretty clear. Now, this is a legal requirement to ask the platform to enable this open participation of all the parties involved. Who are the parties involved here? First of all, of course, copyright owners, copyright holders. This is one party with stake in the process. And how about the others? The merchants. They are doing business on the platform. They're sending out the goods and services they want to sell on the platform. If their business will be shut down or closed, the listing will be disabled, they must have a stake here. There's another stakeholder group. How about the other groups? Just think about it. The consumers. The consumers, the parties involved here, yes, they are. So if all these parties involved will be able to express their opinion, and the platform must listen to them. But it seems it's very much a governance process, even though this is governance within the platform. But imagine how enormous the platform could be, and how many people, how many stakeholders are involved. So there's quite potential. Well, then this reminds me that EU law, the GDPR, is one of my favorites. I'm still interested to see the friction in the United States about this GDPR's impacts overseas. I know it's a negative impact for European business running overseas, because the foreign countries worry about whether the data collected from Europe will be able to transfer to the other countries. Well, even though there's a privacy shield between US and EU, there's still a lot of uncertainty. Well, just imagine what will happen between Singapore and Japan. Well, Japan has been working very hard to have an agreement and haven't reached that. And Korea has been working on that for 2 decades. And China have nothing. We don't even have a law, so it's totally unclear. Well, China is seriously drafting the personal information protection law, and hopefully we will see the bill at the end of this year. Look at the GDPR. It's very interesting. I know there's so many provisions, many famous ones, but I noticed a less famous one. This is about how to form the codes of conduct. This is not really about the platform rules. It's about if this data processor or data controller form an association in one sector of business. For example, if they are processing the pharmaceutical data, they form association. And then the associations are encouraged to prepare a code of conduct. And these code of conduct could be approved by accredited authority. But the formulation and the modification of the code of conduct, we see was said they should consult the relevant stakeholder. Wow, this reminds me the parties involved we mentioned just now in Chinese law, and these drafter should have regard to the submission received and the expressions and the wills expressed in response to the consultation. Interesting. This is also a governance process, even though it may not be on the internet, but this definitely enabled the different stakeholder group to express it well, multi-stakeholder participation. So the Chinese law may not be very new, but it's quite new to China. I'll look at another aspects of Chinese e-commerce law. This is about transparency. For all the platform rules, it must be published. It must be publicized prominently, very clearly. And they should provide access and recommend services to all the users, to merchants, to consumers, let the people understand. But, sadly, a few people will read through these very long documents. I guess you all have been shopping online very happily. Did you really read through these terms of services? No? Well, even though you're lawyers? Future lawyers? Right. Actually, this is a modern rules. I noticed one thing that in the future, I guess we'll all be governed by the algorithm. There's an automated system. They are making decisions on behalf of the platform. So in the future, there's even more uncertain for ordinary users. We don't know what happened. It's totally untransparent. And yes, that's another concern. In the Chinese new law, we also have one chapter. This about the how about this AI's AI-enabled contracting process? That's quite interesting. We don't have time to mention that. Let's be focusing on copyright. Okay, let's look at another design also for the governance process. I mentioned the notice and takedown, counter notification. A new legal design in Chinese law is that all these copyright notice or counter notification from merchants will be published. Well, that's interesting. I understand Google has a similar system, but they're not publishing the contents per se. They're publishing the big data, who is submitting this notice, something like that. I guess under the Chinese law, you don't have to publish the contents of each notice and each statement of non-infringement, but you need to publish the data. How many notifications has been sent out, say, from Microsoft? Yes. And also the outcome of the process. Oh, this is quite serious. It means that if a copyright owner has submitted the notification several times, but it's proof that the notification was sent out in bad faith, this is really a public supervision process. Well, this under the spotlight. You abuse, you copyright. That's definitely bad. So what we can see, whether this governance process could enable a kind of a delicate balance between copyright protection and public interest. Well, I know there's a lot of question marks here. For the rules, through this participation of parties involved, these parties could agree the scope, the extent, the measures to be taken. I think this engagement process could be useful. I just talked with Dr. Henny whether a consumer or users could have a say over the development of turn of services. Or, for example, on YouTube, you uploaded a video, you made it yourself, but somebody just claimed that it's BMG is a copyright and is taken down. For these policy, do you have a say when this policy was formed? So this engagement process will enable you to express. We should have a copyright mechanism or a fair use channel to enable you to use some contents even though it's under copyright protection. And also for measures, I understand in China there's a couple of discussions. Is it simply take down, or it could be something else? One suggestion that's been proposed is that sometimes the contents that's being notified may not be taken down. Instead, the uploader could keep the contents there through providing the guarantees. So if you notify I'm infringing your copyright, instead of taking down my contents, I provide the guarantees, maybe a sum of money. I keep the content over there because this is quite critical for e-commerce. This is more than just contents. For example, for the Chinese shopping festival on the Bachelor Days, that single day sales volume could be tremendous. If you take down my contents or shut down my stores on the platform, that would be terribly damaging to my business interests. So instead, I want to keep it there. In the future, if it's proved this is really infringing, the copyright owner could be paid by these guarantees. If it's proved that there's no infringement, then of course there's no loss for any party. And also this public supervision to serve the purpose of governance, especially their new design in the system. If you send out notification or counter notification in bad faith, you have to pay the punitive damages to the party heard. Yeah. And also, this is all quite new. The platform now is enable a kind of alternative dispute resolution mechanism. It means once a notification has been sent to them, instead of simply take down, under the neutral agreement of the copyright owner and the merchant, they could go through either a mediation or an arbitration or a kind of a quasi-arbitration without finality. So that in that case, they will go through a third-party neutral to decide it is infringing or not. This is the online system, and it may not be done by the platform itself. It could be delegated by to a third party, to professionals. For Alibaba, they have a public jewelry system. I researched their system. That's an online process, but it's very unclear whether this really jewelry, which means this should be a judge. Who is a judge? Or it is only a kind of a consultation process. It won't really deliver the outcome. So there's a lot of possibilities to handle this issue. It's not only just one way, notice and take down. Okay, look at the liability part. And unfortunately, this is the last part for me to talk about. If you look at the Chinese law, the liability of platform is the last resort. So all through this copyright protection system, the priority is not to impose the liability on the platform. Instead, is to facilitate the government, is to facilitate the platform, to improve the governance, to prevent the conflict or infringement. So they shift the focus from the final punishment to the in-process management. And also for Chinese law, this is pretty clear, it's liability with what? Only the platform know or should have known that is merchants is infringing on the platform, it is liable for that. It is not strict liability, it's pretty clear. So, and also the last one, I guess many people will disagree. And the Chinese law actually is no general obligation for monitoring or surveillance the contents for the purpose of copyright protection. Well, just believe me, there's really no such legal obligation for copyright protection. But of course, they do have obligation of censorship for the government. If it's something inappropriate, definitely this platform will be responsible. But for copyright, no such general obligation. And let's have a last look at the ongoing process in Europe. I don't know whether the Council Commission has a rich agreement with the European Parliament. Is this a directive of copyright in digital single market really working out the two controversial articles, Article 11 and Article 13. The 13 has, okay, this is my understanding, may not be precise. Basically, it requires the platform, the content platform, to monitor and proactively screen the contents uploaded by the users for copyright infringement, or they face liability. Well, this is very strict arrangement. To me, it's even draconic. Look at here, it's different from Chinese law. Unfortunately, we still haven't got this general obligation imposed on the platforms, for the purpose of copyright protection. And I will be very interested in how would this be implemented in Europe. But you don't have to worry about it. Because of Brexit, it is not going to be applicable in UK. Okay, very good. So thank you very much. Yeah, I'd be happy. Thank you.